Breaking tonight, the special counsel Jack Smith's case against Trump in major jeopardy. The Supreme Court signaling it will help Trump delay his election subversion trial even further after today's crucial arguments on presidential immunity. The justices signaled, they haven't ruled yet, they signaled that they want the lower court to sort through, one by one, which of Trump's actions were considered official presidential duties and which were private before making a decision on immunity. They wanted as specific as possible. And this possible delay being signaled by the court, coming as it appears justices will ultimately reject Trump's attempt to throw out this case on the basis of absolute immunity.
My question is whether the very robust form of immunity that you're advocating is really necessary.
I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
The framers did not put an immunity clause into the Constitution. They knew how to. Wasn't the whole point that the president was not a monarch and the president was not supposed to be above the law?
So they're not buying the immunity argument, but they're not looking like they're going to move on it quickly and make a ruling and move this January 6th case forward either. Evan Perez is out front. So, Evan, I guess that's the confusing thing. It appears clear how they view it, but in the specifics of this case, they want to be very narrow and specific. So if they send this immunity issue back to a lower court, what does that happen? What does it do to the timeline?
Well, the timeline is still very, very complicated. There's very, very little room for Judge Tanya Chutkan to maneuver, Aaron, because we're looking at a ruling likely at the end of this term for the Supreme Court, which ends typically at the end of June. It is possible they go into the first week of July, but here's the deal. Once they rule, and if they ask the judge to go back and review the specific acts to determine which is an official act, which is not, then there might be more legal proceedings for her to oversee. There is also a possibility that Donald Trump will try to go back and try to appeal some of those decisions. Now, it is very, very possible, still in the realm of possibility, that Judge Chutkan could decide that the acts that are at issue here are official acts, but that they're still subject to this prosecution, and that she wants to get a trial going by August or late August or early September. Again, that possibility remains, and so we will have to wait to see the way the justices write their order to know exactly how much room Judge Chutkan has to try to get this trial going very quickly before the election. Aaron?
All right, Evan, thank you very much. Outside the Supreme Court. And now Ty Cobb, former Trump White House lawyer, he argued against Trump's claim of immunity in an amicus brief filed before this went to the Supreme Court. So Ty, just to put this in the simple terms that we all can understand, today's hearing, win or loss for Trump?
So I think it benefits Trump in the sense that it's almost certain that this case will not get tried before the election, in my view. So it benefits him in that regard. On the other hand, nothing that the justices are going to do is going to benefit his case, other than the delay. Substantively, they will not buy the absolute immunity argument. They certainly don't buy the impeachment judgment clause argument. In fact, I think Sauer's whole argument today, to the extent is reflected in the ultimate opinion, will only be reflected to the extent that he made the concessions that the bulk of the conduct alleged in the indictment is actually private acts.
It's private acts. All right, so there was a key moment for you. The Trump-appointed Justice, Amy Coney Barrett, was in a back and forth with the former president's attorney and basically talking about this issue, got him to admit that a lot of the actions after the 2020 election were not official presidential duties. So this is the moment where some of this played out. Let me play it.
I want to know if you agree or disagree about the characterization of these acts as private. Petitioner turned to a private attorney, was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results. Private?
As alleged. I mean, we dispute the allegation, but that sounds private to me.
Sounds private. Petitioner conspired with another private attorney who caused the filing in court of a verification signed by petitioner that contained false allegations to support a challenge.
That also sounds private.
3 private actors, 2 attorneys, including those mentioned above, and a political consultant helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding, and petitioner and a co-conspirator attorney directed that effort.
You read it quickly. I believe that's private.
And then later he says Trump's phone call with that infamous one with the Georgia Secretary of State, Brad Raffensperger, where he says, find 11,780 votes, I just need one more, was not an official act. How big of a concession is all of this?
Those are all huge concessions. And to the extent that this does get ultimately remanded to Judge Chutkan for additional findings, that will fill her hand in terms of her ability to move the case forward. I don't think the Supreme Court is focused so much on the actual Trump indictment as they are concerned about hamstringing future presidents in terms of restraints on their ability to act officially without fear of retribution by their successors. So
it sounds like what you're saying is where they're going to come out on this. It may be more specifically defined, but where they're going to come out on it is very different. Now, that may delay it, but it's very different than how Trump has defined this, right? Which is a very black and white issue of, if you are going to hold a former president accountable for anything he did while in office, nobody will want the office. It'll be completely robbed of all its power because they'll be afraid of being charged. Here's how he makes that argument.
If you don't have immunity, you're not going to do anything. You're going to become a ceremonial president because otherwise you're going to be prosecuted after you leave office.
So that was just today, ahead of the hearing. Now, in the hearing, Justices Gorsuch, Kavanaugh, and Roberts each said something that maybe some have interpreted to sort of potentially be supportive of what Trump said. Let me just play them all and then get your take on it.
What would happen if presidents were under fear that their successors would criminally prosecute them for their acts in office?
Conspiracy to defraud the United States can be used against a lot of presidential activities historically with a creative prosecutor who wants to go after a president.
You know how easy it is in many cases for a prosecutor to get a grand jury to bring an indictment.
But you do not interpret those three statements as supporting Trump's immunity argument.
Not at all. I think, and I think they're overstated. I mean, yes, there are a parade of horribles that people can imagine, but they're obligated to deal with, what's in front of them. You can't, for example, the indict a ham sandwich. There's a, the government proceedings are usually entitled to, the presumption of regularity, and in this case, that would extend to grand juries and, honorable elected officials. Yes, there are possibilities that people will be corrupt. In the approximately 250 years of our nation, this has never happened before. Trump is the issue, not what could happen. And to the extent Trump's committed these crimes or alleged to have committed these crimes, that's not going to be waylaid by what they do.
So you were when predicting the Supreme Court, your track record's pretty good. 9-0 was your bet for the Colorado ballot case. How do you see this going, and essentially when are we going to find out?
So that they will absolutely not find absolute immunity for Trump, and in fact they'll find that while immunity may be constrained in connection with Article 2 duties and some collateral discretionary acts, that there's a fact-finding process required to determine the distinction between official acts and whatever the allegations are that would support an indictment. I think they will lay out that line and then remand it to the district court for findings consistent with their guidance. I think what you saw today was a lot of frustration with the D.C. Circuit opinion, which sort of said, yeah, this is all reprehensible, no immunity, but it didn't draw the sharp distinction that the Supreme Court clearly intends to do in terms of where is the line between official acts and how much can the criminal law impose upon the freedoms given to the president under Article 2.
So is there any chance this goes to trial before the election?
Not in my view.
No. Next year, if he doesn't win.
If Trump wins, this case is dead. It'll be like it never happened. If he loses, it'll go next year.
All right. Ty Cobb, thank you very much.
My pleasure.